Good morning, Ms. Pace. Ma'am, you were charged with driving on a suspended license. You were facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
6 months in jail for driving on a suspended license. Sounds extreme, right? But here's the catch. Once you've been caught before, Texas treats it like a repeat offense, and suddenly that simple ticket turns into real jail time. Do you think that's fair punishment, or should second chances matter more?
Yes, Judge. On January 2nd, 2025, the officer observed the defendant's vehicle at the 900 block of Burke Road. He ran the license plate and it had a return of an expired registration as of November 2024. A traffic stop was conducted, and the defendant was not able to provide a Texas driver's license, so instead the defendant provided a name and date of birth. The defendant stated she did not have financial responsibility on the vehicle.
The judge shuts her down instantly, and that's not just courtroom drama, it's survival advice. Defendants often talk themselves into deeper trouble by trying to explain or justify what happened. In fact, the number one mistake people make in court is forgetting the golden rule: less is more. If it were you, would you bite your tongue or risk speaking up to defend yourself?
And the defendant was shown to have a suspensible with multiple Class C warrants.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case.
Can I say something?
Please don't. You have the right to remain silent. Exercise that right. Do you have the ability to hire a lawyer?
Yes, I do.
You don't want a court-appointed lawyer?
No, I don't.
Okay, so we'll give you time to go hire a lawyer. I am making it a condition of your bond that you're not to drive unless you have a valid Texas driver license and liability insurance. And I'm going to have you sign a promise with me today. Doesn't matter what's going on in your life. If you want to drive, go get a license, get liability insurance. If you can show me that, I'll take this restriction off. Happily. Okay? Bless you. Did you sneeze?
No.
Okay, man. So I'll have you sign this reset. I'll have you get with Victoria for a reset, and then we'll get you out of here, man. Okay? Thank you.
All right, Judge. Next is page 11. Reyes, come on up.
Good morning, Mr. Reyes. Sir, you were charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 2nd, 2025, the officer was riding with HPD Traffic Crimes Task Force, and a group of vehicles was meeting at 430 West Parker Road in Harris County, Texas. The officer observed the defendant, who was 18, brandish a firearm while walking around his vehicle, and the defendant exited from the motor vehicle on the driver's side, walked around the motor vehicle while brandishing the handgun, and then sat in the front passenger side seat. A traffic stop was initiated, and the officer made contact, and the defendant admitted to carrying around a handgun, which was found under the passenger seat in the motor vehicle where the defendant was sitting.
Mr. Reyes, I'm going to find that there's probable cause to go forward with the case. What are you doing with yourself these days? Are you in school? You graduated from high school? Okay. I'm ordering you as a condition of your bond not to be in possession of weapons. You are not allowed to have a weapon. Do you understand? If I find that you have a weapon and you pick up a new case, I'm going to revoke your bond. I will put you in jail. Do you understand? Tell me, you want a lawyer?
Yeah, I'm hiring one.
You don't want a court-appointed one? You do one?
Yeah.
Okay. I just fill out an application. Let me see if I have an application on file. You fill out an application for me. Let me take a look at it, and then I'll appoint you one here in a bit. All right? Come on. Do you mind, Ms. Brown, giving him an application?
All right, Judge. Next arraignment is page 13.
Can you
Scott,
file?
come on up.
No.
Counsel, do you have an arraignment?
No, approaching for bond violation.
All right, we're doing the.
Bear with me. I think we're close.
I have one.
Are you Mr. Scott? Mr. Scott, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 4th, 2025, in Harris County, Texas, the officer was dispatched to an assault. The officer met with the complainant, who stated that the defendant and her had been in a sexual relationship, and she confronted the defendant about sleeping with another woman. The defendant became angry and followed her to a gas station, where he pushed her to the ground with both hands, causing pain.
Okay, Mr. Scott, I'm going to find that there's probable cause to go forward with your case. Do we know, have you spoken to her to find out what she wants? Does she want to have contact with him? Does she not want to have contact with him?
Here's the big one, an emergency protection order. Think of it like a legal shield, instantly separating the accused from the alleged victim. On paper, it sounds powerful, but in reality, enforcing these orders can be tricky. Some people see them as life-saving, others as nothing more than paper shields. What do you think, real protection or false sense of security?
Your Honor, we have not reached out at this time.
Okay.
Well, Judge,
Hold on a second. Just don't say anything at this point. I've got a bunch of DAs here. Whatever you say, they can use against you. I can give you a lawyer today if you want one. You know, you can give your side to the lawyer. The lawyers can talk to the DAs, but I don't want you to say anything to make the case any worse. All right. Because I don't know what she wants, I'm ordering you not to have any contact with her, not to be in possession of any weapons. I'm also entering what's called a magistrate order for emergency protection that identifies Ms. Walton as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate any threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Judge, you know the property that she lives, I paid for, approved out on another state and allowed me to get the homeless rights.
Let's do this. Let me give you a lawyer today. I can have them reach out to find out where she lives, what the address is. I just don't want you to have contact with her. I don't want you to go where she lives or where she works. That's it. Okay? I don't know. Let's do this. Let me give you a lawyer and we'll go from there. Okay? Do not leave until you sign our bond conditions though. Sorry?
Thanks for respect to now my kids, if you're represented to approve the court 1990.
So hang tight with me. We'll help you out. Don't worry. Okay? Please. Can you, hey, no contact, no weapons.
Last one for now. Counsel, you may approach.
So that was the last one.
For now, it's just,
No Spanish? No.
no, just.
Wow. Okay. Hi.
I'm Aaron Durden.
Okay. Come up, Mr. Durden.
November, toward the end of November, got an interlock at the end of November. His very first date to go have it recalibrated was at 12/29. He was out of town on that date, didn't get back until the next week, was locked out. I got an email on Monday from the trial officer saying that he was locked out and notified you as well. He went the very next day, got it fixed, and you asked us to come here today to address it. He now understands.
I'm not going to play this game with you. Court orders are court orders. You have to follow them. And when you don't, there's severe consequence. And the consequence is you end up in jail. So I'm going to give you a pass now. But if it continues to happen, it's just not going to go well for you. Do you understand?
Yes, sir.
Okay. All right. That's it.
Is our date that we have for the training still on? Thank you. I'll do that.
You ready? Hi.
Who's here for a bond violation because of a lockout, Your Honor? He sends a remedy to that. Apparently his power battery
Do
shuts
you
off.
mind bringing them up?
Unconditional, yeah.
Yeah. Nothing.
Between them and the state, you know.
I'm not going to play this game with you, Mr. Kabir. If this continues to happen, it shows me that you're just don't care about the bond conditions and their severe consequences. Do you understand?
Your Honor, I don't drive this vehicle.
I don't want you to, I'm just telling you, I have bond conditions in place and I expect for you to live up to them. And when you don't, there are severe consequences. Do you understand? Okay. You guys didn't want to add anything? Or did you have something to add? No?
No, Your Honor. No, that was it. That was the only reading you needed.
Okay. All right, man.
Thank you.
Good morning, Judge. May I approach?
Yes, ma'am.
I'm here on an arraignment. My client, Baragan, B.A.
I'm ready when you are. Do you mind bringing them up?
Yes.
Good morning, Mr. Baragan. You were charged with racing on a highway. You were facing up to a year in jail. I'm sorry, up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 5th, 2025, the officer was part of a street racing and takeover task that met at a gas station parking lot in the city limits of Harris County, Texas. The officer was working in a plainclothes capacity and was following the group from one location to another and viewed two vehicles race side by side at Highway 290 and Kickapoo Road, traveling westbound. The officer observed the defendant's vehicle and another vehicle slow down to approximately 50 miles per hour before launching at the same time in a competitive manner, accelerating well over 100 miles per hour in an attempt to outpace one another. The officer maintained visual and was able to detain the defendant, the driver of the silver Nissan observed, but was unable to locate the other vehicle.
How fast are we talking over 100?
Let me see if he specified, if it was just that. The officer only said well over 100. He didn't specify.
Baragan, I'm ordering you as a condition of your bond not to participate in this kind of activity again. If I find that you're racing, if I find that you participate in any kind of street takeovers, anything of this nature, reckless driving, donuts, whatever, I will take your ability to drive away from you. Do you understand? Not only that, it is a condition of your bond, and if I find that you do, I can revoke your bond and put you in jail. Can you file those conditions, please?
Yes, Judge.
You're going to reset your case to give you time to fight this thing. I'm going to have you sign a reset, Victoria. I'm going to have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it. And then after that, you'll be free to go. You have a lawyer. Because you do, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells you she can't get a hold of you because you're playing games, you pick up a new case, you've become a danger to my community, I will put you in jail.
Listen closely. The defendant's voice hesitates, stumbles, almost searching for words. Judges notice that. In a courtroom, confidence is currency. You don't just need the right answers. You need to deliver them with conviction. That's why lawyers spend hours coaching clients on how to speak, how to stand, even how to look at the judge. Here's the question. Do you think this defendant is winning credibility or losing it?
You understand? Okay, come on. Thank you.
Judge, I didn't hear, so PC was found, were there state's bond,
States conditions, yeah.
state's bond condition?
Yeah.
Okay, got it. Also, there was one more, sorry, off-docket arraignment that was probation to sent over here. So whenever you're ready, I'll send it.
Okay, who is it?
It's a printout up there, last name Worthy.
He's on probation. Has a motion been filed?
Yes.
I don't know, because the bond's still set at $100, so I don't know if a motion's been filed. Mr. Worthy, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 8th, 2025, the officer responded to a DPS agent who stated he was following the defendant's vehicle and needed assistance on the traffic stop, as the DPS agent was conducting surveillance on an unrelated case. The DPS agent provided a description of the defendant's vehicle, and the officer observed the defendant's vehicle failing to signal a lane change, along with the defendant's third brake light being out. The traffic stop was then conducted, and the officer made contact with the defendant. The officer observed a strong odor of marijuana, and the defendant was asked to step out of the vehicle, and the defendant stated there was nothing illegal inside. The officer located a cigar filled with a green leafy substance known to be marijuana based on training experience with a weight of 0.09 grams or 0.032 ounces. A PC search of the vehicle was conducted, and the officer located an unholstered black handgun inside a backpack in the back seat of the vehicle.
Mr. Worthy, I'm going to find that there's probable cause to go forward with the case. Take a seat for me in the jury box. Okay, come on.
Morning, Judge.
Hey.
Judge, quick question. I have Jonathan Guidry Joyal popped up on my docket. The only issue, I would like to hear PC. The only issue is he's in processing. I don't know if you want to wait till he pops up, or can we hear PC?
Yeah, we can hear PC, of course.
Yes, Judge.
You don't think there's PC?
I think there's two main issues that I'd like to for you to hear.
It's on the jail docket, unlawful camera. Okay, go ahead, Judge.
On January 8th, 2025, the officer observed the defendant's motor vehicle fail to signal for 100 feet prior to making a lane change twice from lane 3 to 2 and then from lane 2 to 1 on East Tex Freeway in Harris County, Texas. Officer observed further movements between the occupants of the vehicle before the driver, defendant Price, age 19, rolled down the windows of the motor vehicle. The officer approached the motor vehicle and observed a clear plastic bag with green liquid in plain view in the driver handle, believed to be promethazine based on training experience, and a bag with marijuana in the driver door pocket. The weight of the marijuana was 0.82 grams, and the promethazine was 101 grams. The officer observed an AR pistol in plain view on the rear left floorboard or left rear passenger seat where the defendant, Guidry Royale, was seated. Guidry Royale, age 19, and a PC search on the motor vehicle was conducted, and the officer observed another AR pistol inside a black backpack in the right rear passenger seat where defendant Kinnan was seated, along with defendant Kinnan's cell phone. The officer observed an unholstered Glock in plain view adjacent to the first AR pistol on the floorboard behind the driver's seat. The defendant, Guidry Royale, stated the firearms were passed from the front to the rear of the motor vehicle, but would not state who handed him the firearms.
If I may, Judge, here are the issues. So some stuff that's not there is that they were looking at this vehicle beforehand. This is
Remember, this is a probable cause hearing. I mean, I can't get into
correct.
You know,
It's a suppression team. They're looking, they're following. It's a contextual stop. They're following them, waiting for a reason to stop them. The reason that they give is didn't signal for 100 feet. Sounds like they're on the highway. Okay. It's a conclusory statement. They're not stating that anybody else was in danger. They make no mention of.
well, failing to signal a lane change is I mean, it's a traffic violation, is it not?
Well, 100 feet. They don't say at what point he failed to signal, whether or not he signaled at all, whether or not he signaled under 100 feet. They don't state at what foot or feet he did signal. It's conclusory. They don't give articulable facts regarding that. And so because it's conclusory and we don't.
I don't know. I think that there's enough probable cause to go.
Here's a second issue. In the DIMS, this officer is stating that my client says they passed the gun to him and they handed the gun to him. That's what the DIMS says. But the OR says that my client says he doesn't know who tossed them from the front to the back. He doesn't say they handed it to him. He doesn't say they passed it to him.
But there was also an AR on the floorboard where he's sitting.
Right.
Right.
He says that they're not his. There's 4 people in the car. There's 4 people in the car. And only 3 out of 4 get charged with an unlawful carry of a weapon. He doesn't say, hey, they handed it to me. Hey, they passed it to me. What he says specifically is doesn't know who tossed them from the front to the back. This correlates to the furtive movements that the officer is talking about. He never claims possession of these guns. The guns are all in the car. He says they're not his, says the guns are not his, but he gets charged.
So you just take it, then just believe his.
Silence. Nothing dramatic, no shouting, just the slow, grinding gears of the legal process. But don't be fooled. This quiet is when the real battle happens. Prosecutors and defense attorneys are both calculating their next moves like chess players, setting up for the endgame. In court, sometimes the scariest moment isn't the yelling, it's the waiting. Do you feel the tension building here?
Right?
And Your Honor, if I may, and that's why, because they were found in the area where he was seated, the AR pistol, and he is underage at the time. That's the reason why he was charged, because he had them in his immediate proximity in the vehicle.
Yeah, I think that there's enough. Sorry?
It'd be a question of fact, Judge.
Okay.
I think that there's enough. Sorry.
Okay. Understood, Judge. Thank you, Judge.
Thank you, Ricardo.
I'm here on Mr. Reader.
Reader. Yep.
He's finally here today.
Do you mind bringing him out? What's new? Everything all good?
Just, kicking off the new year. Kid stuff. How about you?
Same thing. My life revolves around kids.
Long pants, to still wear shorts.
In this weather?
Are
you?
That's a thing.
My daughter wears them fine, but yeah, my son just refuses.
How old is he?
He's 8. So
He's 8.
Just doesn't care. He'll freeze to death before he admits.
Hopefully he's wearing a jacket and a sweater.
Looks comical. Yeah.
I love shorts as well, and I hate wearing pants too. So.
That one's after.
Are you opposed?
So I'm not opposed to a bond. I'm just opposed to a low bond. And so council has shared some more information regarding, because we haven't been getting, it's another one of those, we can't get a hold of the people from the demanding jurisdiction. It's one of those, because it's a 2B warrant, it hasn't been assigned to a prosecutor yet. And so we were trying to get a hold of the actual investigator for this charge, and extradition investigator, but we couldn't speak with the original investigator. So my facts are very, very limited. We don't.
I'm happy to give you some background, Judge. Mr. Reeder, military veteran, was a medic in the Pacific, in Korea, meritorious awards, done well. When he finished with the military, the Army, lived in Georgia, then was hired over here by a very reputable hospital and medical center. He's the lead administrator. He was referred to me by the chief neurologist of this hospital. What ends up happening, he is in a custody dispute, and I believe Judge Kirby's, is that the judge, over in family court?
Here or over there?
Here. As this custody dispute sort of soured for his future ex-wife, he shows up at his hospital to go to work and is sworn a warrant that he had no idea about. Apparently, this is some allegation that occurred in Georgia in June of 23. No report was made at the time. I think the state will confirm that. It wasn't until the custody issue here started to go south for his future ex. She then makes an online report in DeKalb County, Georgia, who accept charges without ever even talking to him, getting his side of the story. There's actual video evidence, I'm told, of what happened that's been litigated in family court. They're not responding to the state. All we want is a low bond so he can go deal with this there. He's not a flight risk. He's not family here. He's obviously got a good job. His boss is the one who brought me in on this. And so, I don't want to ask for a dollar bond, but I ask because it is a cash bond, and he's going to have to go hire a lawyer to deal with this.
So you're not going to go represent him over there?
I'm not. Well, I'm going to get it. I know. I stay in my lane.
Got it.
We're going to find somebody in DeKalb County that'll make this go away.
So, Mr. Reeder, you are wanted out of the state of Georgia for aggravated assault and cruelty to a child. What we have here is, I don't know you. I've never met you before, but my main concern are two. Are you a danger to my community? And number two, most importantly, are you going to go back to Georgia? I have to make the bond sufficiently high if I give you a bond so that you're going to go back, because you are, as everyone, it's an inherent flight risk because you're a fugitive from.
Judge, if I could, one other thing. The aggravated assault, my understanding from Georgia, is the impeding breath statute here, and the child part of it is the allegation is the 12-year-old child witnessed this. So it's not, there's no weapon involved or anything like that. It's a simple domestic violence situation.
Now it's money time, literally. The prosecutor asks for $10,000 bond, the defense begs for $1,000, and the judge slices it down the middle at $5,000. That's classic courtroom poker. But here's the gamble. If the defendant skips town and never shows up in Georgia, not only does the money vanish, so does their freedom. So imagine you're in their shoes. Take the risk and run, or show up and fight the charges head on.
Any prior criminal history?
No, he has no other history, Judge. And so I'm not able to confirm, but that seems logical in terms of when the warrant was dropped, but it is correct. The charges, the Texas equivalent would be impeding breath, and I guess, I don't even know if we have.
You don't know this with certainty that
Oh, no,
that's
for the
what,
charges it is, but for the date, I don't have any other information. Like I said,
I don't know, the actual, what the facts, what.
Oh, yes, the strength.
Impeding breath, or whether it's
Impeding breath
shooting a gun.
And then cruelty is strangulation, and the cruelty to child is the fact that the 12-year-old witnessed him allegedly strangling his wife. So, but regarding that, because of the nature of the charge, it's a state request $10,000 bond. And so.
You're okay with the
With
bond?
a bond being set because he has no prior other criminal history. He hasn't exhibited any other information I could find that he's a flight risk. So.
Okay. So state wants a $10,000 bond. What's your counter?
My counter would be 1,000, Judge. He's not going anywhere. He's got a good job here. He's got support here. I'm here. They're not bringing me here to run away from anything. We're gonna go fight this case and clear his name.